On a pace to finish by August the 31st. The sooner we can finish, the better. Each day of operations brings added risk to our troops. But the completion by August 31st depends upon the Taliban continuing to cooperate and allow access to the airport for those who we're transporting out, and no disruptions to our operations.
House Minority Leader Kevin McCarthy says the U.S. should stay in Afghanistan as long as it takes to evacuate every U.S. citizen, adding that it's the only thing that the House and Senate should focus on until then.
We are just 3 weeks away from the 20th anniversary of 9/11. At no time should America ever bend or allow the Taliban to tell us when we have to stop bringing Americans out.
Mr. Biden says in the past 12 hours, another 19 military flights carrying 6,400 evacuees and 31 coalition fighters carrying 5,600 left Kabul. The president thanking the House for approving a $3.5 trillion budget resolution and setting a vote on the infrastructure package for next month.
Today, the House of Representatives taken significant step toward making a historic investment that's going to transform America, cut taxes for working families, and position the American economy for long-term growth.
At this hour, the House is taking a vote on the John Lewis Voting Rights Act to send it back to committee. The CDC's latest COVID-19 forecast shows daily hospitalizations could more than double by mid-September. Stocks closed modestly higher, enough to push the NASDAQ and the S&P to new highs. You're listening to ABC News.
Staples Connect has everything for back to school.
From the KMET Weather Center for Beaumont and the Pass area, an excessive heat watch goes into effect Wednesday. This afternoon, it's going to be sunny and hazy, high 92. Mainly clear and hazy tonight, low 70. Hot Wednesday, we'll have sunshine, haze, and areas of smoke, high 98. For the Inland Empire this afternoon, we'll have a sunny, hazy sky with a high temperature of 94. Palm Springs, sunny and hazy, high 106. I'm meteorologist Jim Minaldi for Smart Talk 1490 KMET.
Take KMET 1490 AM with you everywhere you go by downloading our free smartphone apps found on the KMET website, KMET1490am.com. You can also go to the Google Play Store or the Apple App Store on your phone to download the free app. Now you can listen live or play any of your favorite programmers' podcasts using your smartphone. Go to KMET1490am.com and download your free phone app today.
The following is a paid program. Views and claims expressed are those of the program producer and are not endorsed by this station. Opinions expressed are not necessarily those of radio station KMET, its management, employees, or affiliates. The WK Law Power Hour is here to take you from zero to hero in legal knowledge in 60 minutes. A law firm with 40 years of experience is ready to give you legal guidance you need for free. What could be better than that? Amazing stories about actual cases, interesting and informative guests. Listen, watch, call in. Come ready to learn. And now your host for WK Law Power Hour, Paul Wallin.
Good afternoon, everybody. This is the WK Law Power Hour. I'm Paul Wallin, senior partner of Wallin Klarich. We have an extremely successful law firm in Southern California, and we love giving free legal knowledge to people and free legal advice. Those of you that are watching or listening, we'd love for you to call 951-922-3532. Legal knowledge is power, and in our society, we want you to go from zero to hero in just 60 minutes of our program as it relates to legal knowledge, to protect yourself and your friends. Legal knowledge is all kinds of legal knowledge. Of course, it's legal knowledge as to what you should do if you get a traffic ticket. It's also legal knowledge as to what you should do, what could the consequences to you be if you don't take your CV-19 vaccine. Could you lose your job? Could you lose unemployment? Could you lose your benefits? So many things are going on with the law. The more legal knowledge you have, the smarter you are. The less legal knowledge you have, the more likely it is that you're going to get ripped off. If you have any legal questions or you have a pending legal case, you can call us at 877-466-5245, and we'll be glad to give you a free consultation. I've been a lawyer for 44 years. I'm the senior partner of our law firm, and the whole purpose of this show is to keep you up to date of all the happening with legal issues in our country that are going on all over the place. It's also a place where you're free to ask any kind of legal question you have, and if we can help you, we'll be glad to do so. For example, do you have a traffic ticket pending? Can you get around it? If you can get around it, do you have to go to court or can you hire a lawyer? If you're going through a child custody battle, what do you have to know to maximize your chance to keep custody of your children? How about child support? When are you eligible for child support and when are you not? How about spousal support? How long do you have to be married before you can get spousal support if you're going through a divorce? What happens if your husband or wife are cheating on you and then you want to get a divorce? Can you get some extra child support or spousal support because of that? No. Even though it's not good for someone to cheat on someone, in most states that are no-fault divorce, the court could care less whether or not your spouse has been cheating on you. All of these legal issues are very, very interesting and ones that we answer every day at Wallin Klarich and provide free legal advice. If you need a lawyer to represent you in court, of course you can hire us, and we've been representing people for over 40 years. So you can call now at 951-922-3532, and we'll be glad to answer your questions. Today, I have the great privilege of having as my only guest my law partner, John Lynn. He is a brilliant lawyer who defends people accused of serious crimes, and also he defends parents who've had their kids taken away by the government. And that's extremely sad when that happens. He'll be a guest for the whole hour. You can call in if you have any questions about criminal cases, traffic cases, DUI cases, or if you are going through a child dependency case or someone you know is, and you're trying to help them get their children back. For those of you that are watching on TikTok, there's been several hundred followers already following me on TikTok. I came on a little earlier. So many questions about the coronavirus and whether or not you can be legally required to take the virus. Some people don't know that in a few states, they're actually trying to pass laws that say if you are unvaccinated and refuse to take the vaccine and then you get the virus, you shouldn't be allowed to go into a hospital to get treatment, because now so many hospitals are filling up that would be depriving people that took the vaccine. People in Alabama the other day, a couple days in Alabama, they ran out of ambulances. Imagine that. You have a heart attack and you can't get an ambulance because all the ambulances are taking COVID patients to the hospital. You can get a tremendous amount of legal knowledge by going to wklaw.com. That's our website, wklaw.com. You won't regret it, I assure you. If you go to that website, you can get information on so many areas of law. wkfamilylaw.com if you have a family law matter. After the break, we're going to be talking to John Lynn about so many interesting topics. However, if you want to call at any time, like I said, we can talk about COVID and whether it is legal for college students to be told they cannot go to college unless they take the vaccine. Some people think that's horrible. Other people think it's exactly how it should be. So when we come back from the break, I would like you guys to stay with us, and then we'll have John Lynn on. And if anyone wants to call in, instead of doing a duet, 951-922-3532 for Focus John 77. That's 951-922-3532. Let's go to the break, and we'll be with John Lynn after the break.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
Hey, are you okay to drive?
Yeah, I'm fine.
17 to Central
If you've been arrested for DUI and are facing DMV in court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
When you have a warrant for your arrest, it's a very scary time in your life. When you drive a car, you have to be extra careful that you do not commit any sort of moving violation. You have to be looking over your shoulder, checking for police officers. Will you be stopped and thrown in jail? What a horrible feeling. For over 40 years, we have helped thousands of persons resolve their problem with having a warrant. In some cases, we can actually appear in court for you without you being present to recall the warrant. Depending on the facts of your case, you may never have to do 1 minute in jail. Stop living in fear. Call us now for a free phone consultation at 877-4-NO-JAIL. That is 877-4-NO-JAIL. Or go to wklaw.com. Isn't it time to get your life back? We will be there when you call.
Hi, we're welcome back. And everyone, I think we have a caller, is that right? Okay, Josh, how can we help you?
Quick question. All right, so I live in another state. Obviously, it's not California. My kids are temporarily in the custody of the state. Now, my concern is they made that new law where if you're 12 and older, you can get the shot without the parents' permission. Are they allowed to give my children the vaccine without me knowing or being brought into the conversation?
That's a really good question, sir. First of all, did you say you're in California?
No, I'm in Maine.
Okay. Well, it would depend on what the law is in your state, but I'll tell you in California, if the county that you live in, if they have taken temporary custody of your child away from you, then during that period of time, they can make decisions as to whether or not your child gets the vaccine or not. If they haven't taken child custody away from you and your legal custody rights, which would include to decide what shots your son gets, then no, they can't. You have to find out whether you still have legal custody or you do not have legal custody of your son.
Right, I do still have legal custody. I don't know.
Then if you don't, do you have a lawyer?
Yes.
You should ask your lawyer specifically because Maine law is different maybe than California, but I'd be shocked if they could make that decision to give him the shot without your permission or the mother's permission. Does the mother have legal custody?
Yeah, we're still together and everything.
They normally can't take those decisions away unless the court makes a specific order. But to be sure, you should talk to your lawyer that you have because they would definitely know Maine law, okay?
Okay, thank you very much.
No problem. Thank you very much. Okay, thank you for that call. And now I want to introduce John Lynn. John is a partner at Wallin Klarich. Hi, John. How you doing?
Hey, Paul, I'm great. How are you?
Fine. First of all, John, tell us how long you've been a lawyer.
So I have been a lawyer since March of 2009. So it's about 12 and a half years. I passed the bar in Florida in 2009, and then I came here to California. I got licensed in California in 2013.
Okay. And when you were in Florida, did you practice criminal defense there?
Yeah, so I graduated law school, and then the first job I got was in West Palm Beach, Florida. I was a public defender there for 4 years, and I've come here to California. I've been a criminal defense attorney since I've been in California, so I've been doing criminal defense exclusively since I've been an attorney, first on the public side and now private.
Could you tell us why, of all the different jobs you could have taken in 2009 when you became a lawyer, can you tell us why you chose to become a public defender?
Sure. So when I was in law school in Minnesota, that's where I went to law school. So I graduated there, had to get out of the cold. But my second year of law school, they have a student practice program when you're in law school. So your second year of law school, you can actually go to court and argue parts of cases under the supervision of an attorney. So one of the first jobs I had was as a doing student practice for the public defender's office in Minnesota. And I knew that I was interested in going to court as part of being an attorney. I wasn't sure before having that job if I wanted to go into criminal defense. So that position gave me the chance to actually meet with people, present their case to the judge, handle different stages of a court case while still being in law school. And that experience showed me that how important it was to have a representative when someone's being accused of a crime. So I went from that position to getting the job as the public defender after I graduated. And I very much enjoyed the job. I got to help a lot of people who weren't able to afford a private attorney and who were in a difficult position. So that's basically how that happened.
Sure. But the public defender's office doesn't pay a very high salary compared to other firms where you might do corporate law or other things, right?
Exactly. So the part of it is doing that. I don't think people go into being a public defender to get rich, and that's not really the motivation. So part of it is getting that experience of you're handed a lot more cases, a lot more responsibility. You're more likely to go to trial or handle things as a younger attorney in the beginning of your practice than later on in your career. So if someone went to go work for, let's say, a big civil law firm, they may not be going to court very often in the beginning. They might be doing a deposition by the time it's their fourth year there. Whereas if you're a public defender, you've done maybe 40 jury trials. So you're getting a lot more responsibility, but you're taking advantage of that because it gives you a lot of valuable experience when you go out to get other positions. So a lot of people know that the money isn't all that great, but it's really good to get that experience if you're interested, which I was. So.
Okay. And you've been now with Wallin Klarich for how many years?
It's actually almost 9 years, 9 years in about 2 weeks. So I started here in September of 2013.
9 years. Wow, that's a long time.
8 years.
Okay. And you are a partner, right, at our law firm?
Yes. Yeah. So I started out as an associate attorney. I'm now a partner. And what that basically means is that I'm involved in things having to do with running the firm in addition to managing a caseload of mostly serious cases, criminal and dependency cases.
Right. And that's what I was going to ask you next. So one area of law that you represent people in for our firm is child dependency law, right?
Yes. So in addition to the serious criminal cases, I handle a number of child dependency cases.
And could you tell us what it is? What is a child dependency case?
So just like the person who was calling earlier, when there's a situation that social services believes there's abuse or neglect, they get involved in removing a child, the case gets referred to court, and the parent has a right to see what the allegations are and potentially contest the allegations in court. That court process is the child dependency process.
And what courts do you handle child dependency in?
So there's one in Los Angeles County. There's one in Orange County. That's where the majority of my cases are out of. Orange County, there's one single courtroom, 4 courtrooms, 4 judges. Los Angeles County, it's a lot busier. We got about, I want to say maybe 25 judges in Los Angeles County Dependency Court. So majority of the cases I handle are in those 2 courts.
Okay. And do you find those kind of cases interesting, challenging? How would you define your approach to those child dependency cases?
Yeah, so I think both child dependency and criminal cases, I think we're talking about people's fundamental rights that the government is seeking to basically infringe on. So there's really nothing more important or more personal than somebody's ability to be with their children and their family. And so what we want to do is we're going to get it. What we try to do, or I try to do when I'm helping people in these cases, is look at what the accusations are. And if somebody is denying it or they're being accused of something that's not correct, we want to put together all of the facts and information to show the court, to show the judge and all the parties who are involved why this person hasn't done what they've been accused of doing. But then there are a number of dependency cases we have where there is a problem. Somebody might have a domestic violence issue or a drug issue. And in that case, we're working them through a process where they can go to counseling or classes and get the skills that would make them a better parent so that at the end of that process, they get their children back. Either way, either route that we're going on, the goal is to reunite a parent with their child and reunite a family. And that's part of what I'm passionate about, is representing people in those situations, just given how important it is.
In some cases that you've handled, a parent will come to us because they were arrested for domestic violence, and it's alleged that they struck their wife in the presence of their children. In those cases, can a person actually then have to go to both courts, the child dependency court and the criminal court?
Absolutely. So there's a number of allegations in dependency court that will cross over into pending criminal cases. And that's why if you can get an attorney that is able to handle both sides of the cases and use certain strategies in dependency case to benefit the criminal case, then you could have a combined process, so you're protecting yourself on both sides. So a lot of times in those cases, we'll talk to our clients about exercising their Fifth Amendment right, not saying any statements that might be incriminating in the dependency court. We'll talk to them about potentially calling witnesses and getting testimony in the dependency court that could then potentially be used to protect the client in the criminal case if it's favorable. So there's 2 different processes in terms of what somebody's going through, but the goal is to have a strategy that works for both, and that's what we do in those situations.
I've also handled many serious criminal cases and dependency cases, and I find that sometimes what goes on in the child dependency court is more stressful. The burden of proof is less. They're talking about losing their children, that emotionally sometimes that court is as, if not more emotional than the criminal court. Is that what you find too?
I think that could absolutely be true. I mean, let's compare a situation where somebody in criminal court, maybe they could get put on probation or they could be taking classes or something like that. That is not the same consequence as having a child taken from your house and having to watch your child with a monitor and having to go through, or possibly having your children taken to foster care or something like that. It's just such a personal thing that sometimes that is more stressful than even potentially going to jail for some people, and understandably so.
So you've practiced criminal defense now for, like, you say, how many years total? 12?
12, yeah. I go 12 and a half.
Okay. A lot of people, I guess, criticize someone who will be a criminal defense attorney because they say, how can you represent someone that either is or might be guilty of a crime? What's your take on that? I'm sure you've heard that a million times.
Sure. Yeah. And I understand why people say that. But at the end of the day, I'm not I'm not defending breaking the law or doing things that are wrong. I'm enforcing somebody's legal rights. So we have, I think, a really good system in this country. It's an adversarial system. We have a prosecution and we have a defense. And my job is to be, in order to make the whole system work and to be a check on the prosecutor having power that goes too far, my job is to advocate for my client. So if what that means is, it's not up to me to make a determination whether the client is guilty or not. It's up to the prosecutor to present enough evidence to show that he's guilty to a judge or to a jury. And so that's my role, is to challenge the strength of the evidence. And in cases where my client may have done something wrong, which happens, people make mistakes, my job is to advocate for his position so I can get a fair outcome and resolve the case in a fair manner so that it's not unfair to my client.
In my experience, many times the district attorney's office will charge someone with many crimes, and the penalty for all those crimes could be 20 years in prison. And the client will come in our office and we'll look at the case, and yes, he may be guilty of one of those crimes, but not all of those crimes. So in those kind of cases, isn't it extremely important to have a lawyer fighting for you?
Absolutely. And I just am handling one case that is like that now, where just looking at the reports, it did appear my client had done some things that he was accused of, but the charges that were actually filed by the prosecutor were much more serious and potentially leading up to life in prison. And when you look at the actual facts and what they were able to prove, they were not able to prove what they charged. And even though some of the things he did. So that's part of my role, is just to make sure that there's a check on what they're doing. There's a check on the power of the government to come after somebody, to prosecute somebody and try to have them locked up. I'm the other set of eyes. I'm there to be an advocate for my client, to protect my client's interests.
Sometimes when a client comes in the office for the first time and you know what he's charged with, don't you have a difficult time in the emotional part of that initial interview, because you know that the person's facing the possibility of, say, 28 years in prison, and giving that person and his family that information is going to be so traumatic. How do you give that information and also calm them down and explain that doesn't mean they're going to get the 28 years in prison?
Right. Absolutely what you're saying is right. I mean, part of our job, and you've been in this position as well, is that we're dealing with issues that have really serious consequences for people. And part of it is we want to help people through this process. So we didn't get involved in writing contracts or getting into car accidents or things that don't have somebody's literal life on the line. But what I try to tell people is I have an obligation to give you all the information about what could potentially happen. And then we're going to talk and make decisions based on all the information that we have together. And I know it's a serious thing that we're talking about, and I know we're talking about serious consequences, but if I were in your position, I would want to know all of what I was facing as well. I would want to know what the chances I had of beating it, what the odds are, what my options are. I mean, the analogy is, if you go to a doctor's office and you might have a 20% chance you have cancer, you would want to know what the chances are. You would want to know how serious the cancer is and what the operation would be. And that's sort of what we're in the same position to do, is we're saying these are really serious consequences. This is a serious issue, and here's what our options are. Here's what we can do about it. And that's the conversation we have.
And the whole purpose of that conversation is, as the case goes on, now they have a thorough understanding of what they're facing, and then you can continue to update them as the case goes on, correct?
Right, absolutely. And that might change. There might be developments in terms of things get better or worse for their case. But at the end of the day, I want you to know, here's the severity of what you're being accused of, and here's the process, and here's what your options are. So that's a conversation we have in every case.
And in terms of criminal defense, can you tell us what courts you primarily go to?
Sure. I go to courts throughout Orange County, Los Angeles, and Riverside, and then San Diego. So it's basically all throughout Southern California, primarily Orange County, LA, and Riverside.
Okay. Thank you, John. We're going to go into some specific crimes that John represents people for and discuss how he defends people, what the elements of the crime are, and some personal experience he's had with those specific crimes after the break. So let's go to the break now, and we'll be back with John.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV in court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When you are facing a serious criminal charge, it means you may be looking at many years in prison or doing up to 1 year in county jail. Most people do not know who to turn to in their time of need for expert legal guidance. What you do next can make the difference between ending up in prison for many years or having your charges dismissed and you going free. At this very critical time in your life, you need Wallin Klarich fighting for you. Wallin Klarich has 40 years of criminal defense experience, and they work very hard to do all they can to win their clients' cases. Wallin Klarich has a team of 10 criminal defense lawyers fighting for their clients every day. They help people with cases pending throughout California. They successfully defend cases dealing with murder, sex crimes, all felonies, as well as misdemeanors. Check out wklaw.com for some real client success stories. They offer a free phone consultation to answer your questions. Call them toll-free at 877-4-NO-JAIL. That's 877-4-NO-JAIL. They will be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
Okay, we're back with John Lynn, partner at Wallin Klarich, brilliant criminal defense attorney, and child dependency lawyer. And John, one question I didn't ask you in the last segment is, could you obviously could choose to do another area of law. You're extremely bright. You're a great lawyer. Why do you continue to want to do criminal defense after this many years as opposed to change gears?
Sure. I just think that it goes back to wanting to try to help people through this process and understanding the criminal court process and wanting to be there as an advocate for people. And I think that I have so much experience handling so many different types of cases, and I've seen so many different things that I think my experience is best used to help people who are being charged with crimes, who are facing prosecution in the criminal process, rather than doing something else. Because I think this work is really important, and I want to keep doing it.
Well, and John, your clients love you and you get tremendous results. We're going to talk about a little of those results. I've had the opportunity for 44 years to decide to do something else other than criminal defense. But there's nothing that I would ever choose to do, because there's nothing else I can imagine where you're helping people more that are in the more stressful, distressed time in their life than people facing a criminal charge. And I think the most important thing I want to add is that if you're facing a criminal charge, we're not representing just you. In effect, we're representing your entire family, because everyone is going through it at the same time. And I really love that part of what I do. And I know John does the same. So John, let's talk about some crimes that you're very experienced in, and we represent a lot. The first crime I'd like to talk about is the crime of grand theft. Can you first of all tell us what the crime of grand theft is and how it's different? It can be a felony or a misdemeanor.
Sure. So generally speaking, in California, the dividing line between felony and a misdemeanor is the $950 amount. So over $950 can be a grand theft that's charged as a felony. It's generally what's called a felony wobbler. So that means that it could be, even though the amount's over $950, it could be charged as a felony or as a misdemeanor. And as a felony, if somebody gets probation, that could eventually be reduced to a misdemeanor later. So the general dividing amount in California for most theft offenses is $950. Over that, felony; under it, misdemeanor.
What is the element of the crime that the district attorney must prove to convict someone of grand theft, whether it be a felony or a misdemeanor?
Generally, what we're talking about is the unlawful taking of personal property, money, labor of another person. So that's basically taking something that you're not entitled to. And if you do that by signing a false document, that can be charged as a forgery. If you get paid money or you take money from an employer, that could be embezzlement. But generally speaking, we're talking about some amount of funds or something of value that you took that doesn't belong to you. So
it can be, if it's a felony, you have to have stolen something with a value of $950 or more, right?
Generally speaking, yes.
Okay. But what about the situation where you take something, right? Let's say you take a rental car, right? And let's say at the time you take the rental car, you do not intend to keep the rental car, but you're on a road trip and you get there you're out, let's say we're renting the car for 7 days and you've rented it and the 7 days is up, but you're just like 2,000 miles away. And is it grand theft because you have this car more than 7 days?
No,
you didn't bring it back?
It's really would be based on all the total circumstances of it. So if you have a rental car and you're intending to return it and something unforeseen happens that you're not able to return the car on time, you have a mechanical issue or something like that, you wouldn't be able to be prosecuted for that. But we have had cases where somebody takes, let's say a rental car, or let's say any type of property that they were only supposed to have for a temporary amount of time. And then they take that with the intention of keeping it and not returning it. That could be charged as a theft. And I think we've had some cases involving rental cars. Usually the facts are that the rental car company is contacting this person, sending them multiple letters, things like that. There's another charge somebody could have. Let's say that you're riding in the back of an Uber and somebody happened to leave their credit card. Now that's lost, you take it. And if you're intending to try to find that person and give them the card back, that's not a crime. But if you then take it and try to use it on your own, that falls into what's called misappropriation of lost property. So really what it has to do is, whether it becomes a crime or not has to do with the amount of time that you're taking this thing that you shouldn't have it, and then your intention. Basically, how does the person acting? Does it look like they're taking something that doesn't belong to them? That's just basically putting it in layman's terms what we would be talking about.
I understand. Okay, another area of law that you obviously have tremendous experience in is the crime of murder. You've represented many people for murder, correct?
Yes.
Okay. And could you tell us, first of all, the difference between first and second degree murder?
Sure. First degree, the key word, the key difference is premeditation. So first degree murder means that it was premeditated. That means that at some point you made a conscious decision to kill somebody else. That premeditation could happen in a second, but it is the process of thinking through and coming to that conclusion that you intend to kill somebody. If you act hastily or rashly and you don't have the premeditation, then it's second degree murder. Now in California, their first degree murder is punishable by life in prison with the possibility of parole after 25 years. So we were talking earlier, like, what kind of serious conversations do we have when somebody comes in? If somebody's coming in and they're accused of murder, what I have to tell them is, if you're found guilty of this charge, if you go to trial and the jury comes back guilty, the judge does not have discretion to sentence you anything other than life in prison with parole after 25 years. You can't get more than that. You can't get less than that. That is the automatic sentence for a first degree murder. If someone's charged with a second degree murder, that is life in prison with the possibility of parole after 15 years. So that's basically what we're talking about. It's the difference between the two of them.
So if you're convicted of first degree murder, you're going to be sentenced to 25 to life, and there's no chance of probation?
No, not for first degree murder. But what we talk about is, number one, where we're looking at the facts, can we say that this person committed this crime? The second thing is, what is the crime? So murder, because there's the different degrees, if we're defending against a murder case and we go to trial, there's first degree, second degree murder is a lesser included. Then it goes down to manslaughter. Manslaughter is maybe you killed somebody, but it was either in the heat of passion, something triggered you to go and do this, or you were acting in what's called imperfect self-defense. So you believe that you were acting to defend yourself, but that wasn't a reasonable belief when you did it. So we just had a trial, or I just had a trial, where my client was charged with attempted murder. He had shot at somebody, and we couldn't dispute that. He was on video. They had him shooting at this person. We didn't deny that. But the question was, the other person had made many threats to our client prior to the shooting, and whether our client was justified in fearing for him when this confrontation happened. So that was the argument. The prosecutor tried to argue he was guilty of attempted first-degree murder. The jury said he was not guilty. He was acquitted on that. Then the jury went down to the lesser included attempted voluntary manslaughter. So did he attempt to kill this person? He thought he was acting in self-defense, and but it wasn't reasonable. On that issue, we had this is a trial we just did. The jury split 6-6 on attempted voluntary manslaughter, and then it's set for another. We're supposed to come back and do that. So that's what you're going to look at. What could you be charged with? What's the penalty for the charge that you have against you? And then what are some of the lesser includeds that a jury would look at? Now, that's in a case, like I said, where we can't really dispute that our person did the shooting. I'll give you an example of a totally different case.
Wait, before you go to that case, I want to know more about the case you just, in effect, won. So the person was facing 25 to life for the case you just did, right?
Yes, he was facing 7 to life for attempted murder, 25 years on top of that for a gun enhancement. Effectively, when everything was added up, it was 35 years to life.
Okay, and by the jury finding him not guilty of that charge now, and having a hung jury as to the other charges, when you're going to retry that case, does that change his maximum sentence?
Absolutely. So by them finding him not guilty of the attempted murder, that takes the life allegation off the table. So now the amount of time that he's looking at is dramatically reduced, and he's not looking at doing an automatic life sentence. So we're in negotiations now with the prosecutor, but we're in a much better position now than when we went to trial before, because the most serious charges have been taken off the table. And even on the less serious charges, we know that a jury of 12 people could not come to a unanimous verdict. So we take that information that we have from that case back to the negotiating table with the DA, and we say, look, give us a better deal, offer us something better, because the first time around, you couldn't prove the most serious charges, and you couldn't even prove some of the less serious charges to a jury.
You've defended many people accused of murder and manslaughter, and you've had many trials, correct?
Yes.
Do you find the murder trials the most difficult to try as opposed to the other trials you've had?
I think that they're the most serious cases, but that's pretty much all of the criminal cases I handle are very serious. So I just have an approach for all these cases where, as we're getting ready to go to trial, we're just doing a deep dive into all the evidence and all the information, and then we have a playbook. But because trial is a dynamic thing and witnesses are up and you don't always know what people are going to say, in order to be an effective trial attorney, you have to both be overly prepared before going into trial and ready to react to any number of things that happen during trial. So it's a combination of both thinking on your feet when things happen in trial, listening to a witness's testimony and kind of getting a sense of how that's playing with the jury in the moment, but also having a roadmap for what points we want the jury to hear, what things we want them to focus on. So that's true in a murder trial. That's really true in any type of case where we're going to trial. We want to have main points that we want to make for our client, and then be prepared to react to anything that happens that might be unexpected, because there's always going to be something unexpected.
And for people that don't understand how a trial works in a criminal case, in effect, the district attorney loses unless he convinces all 12 jurors unanimously that the person is guilty beyond a reasonable doubt, correct?
Absolutely. Yes.
So in effect, if your client, let's say, is out of custody because he's been able to bail out, and you're able to convince even one juror that he's not guilty, it's very likely that your client will continue to stay free pending the possibility of another trial, right?
Right. So, I mean, we require a unanimous 12-person jury here in California. Actually, interestingly enough, in Florida, where I practice, they only had 6-person juries. Here we have 12-person juries. But yeah, it's required that all 12 jurors are unanimous, and then they believe that the prosecutor has met all the elements beyond a reasonable doubt. And so that's why when I'm picking a jury in every case, I'm instructing them that if you're picked on this jury, understand that it's not 50-50. It's not whether the prosecutor proved the case by a preponderance of the evidence, 51%. This is the highest burden that we have for any type of prosecution. So to convict somebody of a crime, the evidence has to be higher than even taking their children away. So the reason that's what I want to educate the jury, is that the burden of proof is the highest burden. And the reason it's so high is because we're talking about somebody's fundamental freedom. We're not in court arguing over money, and we're not arguing over things that are not somebody's basic freedom. So I've had jurors tell me after they voted to acquit my clients that, well, we thought there was evidence. Maybe we thought it was over 50%. But when you explained to us the high burden that the prosecutor had to meet, we just didn't think that it met that burden. And that's why we had to vote not guilty. Voting not guilty is not the same as saying that my client's innocent or for 100% didn't do anything wrong. It's saying the prosecution hasn't met their burden. They haven't presented enough evidence to convict my client beyond a reasonable doubt.
In many cases, like murder cases, as an example, let's say your client wants to testify in his own defense, and you know all of the evidence and you have tremendous experience, and you believe that the client should not testify because you think overall maybe he'll be subject to fierce cross-examination by the DA. How does that work when you have that kind of discussion?
Yeah, so every case is going to be different in terms of whether I have the client testify or not. And that's going to be a personal decision that I make with the client based on what the facts of the case are. So when we're listening to the evidence come out in a trial, I'm going to try to decide, are we going to gain more by having my client testify versus the potential downside risk of having him be exposed to cross-examination? So at the end of the day, it's my client's decision in every case, but we want to make that decision with my input, because what I want to tell the client is, if you want to get on the stand and testify, that's up to you. I have the experience of having tried many cases and making these types of decisions. I'm advising you not to. In almost every case I can think of, the client and I have not had many instances where the client wants to go against what I advise them to in a trial, when I explain that this is based on my experience and expertise in handling these types of cases.
And in almost all cases, after you have that lengthy discussion with your client, are you able to reach an agreement where the client understands?
I think that, yes, in almost every situation, because, I want to say there could be, I want to say, what do you want to say? What do you want to get on the stand and say? And then keep in mind, they're going to have a chance to ask you questions. If they ask you this, what would your answer be? So we want to have a sense of how my client's going to respond to cross-examination from the prosecutor, which is always a risky thing. And so that's why I'll bring the client into my office. We'll talk about what the testimony might be. I'll prepare some questions that the prosecutor might ask him or her. And then depending on how that preparation goes, then we can make a decision. Depending on how that preparation and how the evidence comes out in trial, we make a decision about whether my client should testify or not.
I see. Okay, well, John, thank you very much for coming on the show. I really appreciate it. Anyone who is accused of a crime would be very, very well served by having John Lynn represent them. He has a tremendous record, so many clients. You can read about him on our website, wklaw.com, and we have been in business since 1981. There are very few law firms that are been in business as successfully as Wallin Klarich has. We started in Southern California in Orange County, and because we've been so successful, we have now offices in Riverside County and San Bernardino County and Los Angeles County, including offices in Torrance and West Covina. And that allows us to represent many, many, many million people. And it's truly an honor to be able to do that. And it's truly an honor to have this program as an outlet. Because if you are to listen to this show, whether it be on TikTok, on KMET, anywhere, you would get a tremendous legal knowledge. And the thing that I want to talk to you guys about is, why is it important to have legal knowledge, right? And I use this as an example right now of what's going on with COVID, because many people are resisting taking the vaccine. And if they choose to resist taking the vaccine, I don't agree with that, of course, but that's not my choice to make. But what I do want them to know is there are consequences associated now with not taking the vaccine. If you live in certain states, for example, like California, and you live in San Francisco area or Los Angeles, you now are restricted from where you can go. You can't go to concerts, you can't go to inside restaurants unless you have proof of vaccination. That is expanding. The same is true in New York City. If you're a college student and you want to go to college, now that the FDA has approved the Pfizer vaccine, more and more colleges are going to be telling the students, sorry, get vaccinated unless you have a doctor's excuse, or you can't go to college. And most importantly, if you're in the military in this country protecting us, we need you to be vaccinated. And President Biden has made clear, and the Department of Defense, that if you don't get vaccinated, you will not be able to continue in the military. A military career down the toilet because you won't take a vaccine approved by the FDA, that would unfortunately be a very, very bad decision. So on behalf of Wallin Klarich, our law firm, and myself, the WK Legal Power Hour is here for one reason: to give you legal education so you know the law, so you can be a strong legal advocate. I want you guys to have a great week, and we'll be here next week with another great guest. Have a great week.
Wallin Klarich Law hopes that you learned something about the law today. Knowing your legal rights is critical in 2021. Come back next week for more WK Legal Power Hour at 3 o'clock p.m. Pacific Time on Tuesdays. You can visit www.wklaw.com for thousands of pages of free legal information, or email the firm at pjw@wklaw.com. Wallin & Klarich will do their best to provide you with legal guidance or try to point you to the proper direction. That's pjw